LGBTQ persons, and same-sex couples. On behalf of the Human Rights Campaign, he co-authored an amicus brief to the U.S. Supreme Court in Obergefell v. Hodges. Professor Sanders has also practiced for 4 years with the Supreme Court and Appellate Litigation Group at Mayer Brown LLP in Chicago. Mr. John Bursch is Senior Counsel and Vice President of Appellate Advocacy with Alliance Defending Freedom. Mr. Bursch has argued 12 U.S. Supreme Court cases and more than 30 state Supreme Court cases since 2011. Mr. Bursch has also served as Solicitor General for the state of Michigan from 2011 to 2013. As part of his private firm, Bursch Law PLLC, he's represented Fortune 500 companies, foreign and domestic governments, top public officials, and industry associations in high-profile cases, primarily on appeal. He was inducted into the American Academy of Appellate Lawyers and serves as a member of the American Law Institute. He also argued Bostock's companion case, Harris Funeral Homes versus EOOC, before the Supreme Court. So the way this debate is going to be structured, we're going to give each speaker 10 minutes to speak, beginning with Professor Sanders and then followed by Mr. Bursch, after which each speaker will have about 5 minutes for rebuttal. And then we'd like to save the last 30 minutes for question and answer from the audience. So as our speakers are talking, please feel free to submit questions through the Q&A chat feature. And yeah, let's go ahead and get started. Professor Sanders, you can take it away.
Okay, great. So thank you to both chapters of FedSoc for doing this and for hosting and for organizing this. I'm a fan of FedSoc's mission, even though I often, sometimes, but often don't align with their preferred outcomes in questions of law and policy. So we agreed that my role was to defend the Bostock Title VII decision, and that assumes it requires a defense. Part of me wants to say what's not to like. The decision extends the policy of federal employment discrimination law, that irrational discrimination, that is discrimination based on characteristics that bear no relationship to an employee's ability to do the job, that's inefficient as an economic matter and socially corrosive and morally wrong as a legal policy matter. The decision is majoritarian. Strong majorities of Americans have agreed since the 1990s that gays and lesbians should have equal rights in terms of job opportunities. And finally, if you don't like the decision or something about the decision, it can be corrected by Congress. This is not a constitutional ruling. But let me try to speak to, or at least anticipate, sort of 3 major lines of criticism of the decision. One, is discrimination against gays and lesbians really sex discrimination? Well, here, this was the heart of the court's analysis, which was simple and elegant. And I'm reading from the decision, from Justice Gorsuch's decision. An employer who fires an individual for being homosexual or transgender fires that person for traits and actions it would not have questioned in members of a different sex. Sex plays a necessary and undisguisable role in the decision, exactly what Title VII forbids. If an employer has 2 employees and both are attracted to men, if the employer fires the male employee for no reason other than the fact he's attracted to men, and then the employer discriminates against him for traits and actions that it tolerates in his female colleague. Put differently, the employer intentionally singles out an employee to fire based in part on the employee's sex. And the affected employee's sex is a but-for cause of his discharge. So again, the complaint lurking underneath this, I think, is this isn't really discrimination on the basis of sex. That's a little too cute. That Congress in 1964 meant to outlaw discrimination against women, not against LGBTQ people. What's salient here is homosexuality, not sex. I think the best answer to that is that there are many things that are now covered as sex discrimination that were not foreseen by Congress in 1964. Hostile environment, sexual harassment, discrimination on the based on the status of motherhood. In a case on male sexual harassment, in 1998, an employer argued that Title VII should not be read literally to protect male-on-male sexual harassment because homosexual assault or boys-on-boys hazing was too far afield from Congress's paradigm case of a qualified woman who's not hired because she's female. And the court, in a unanimous opinion by that patron saint of the Federalist Society, Justice Scalia, unanimously rejected that argument. saying it is ultimately the provisions of our laws rather than the principal concerns of our legislators by which we are governed. And the court has also, under Title VII, said that discrimination that relies on gender stereotypes is also covered. That may not be about discrimination in favor of men versus women, but it's about stereotypes about how men and women are supposed to behave, supposed to conduct themselves, supposed to present themselves. The court said that also qualifies as discrimination on the basis of sex. Social and religious conservatives have actually, and who are, frankly, I think the main people who are concerned with this decision, who would argue this decision is wrong and problematic, social and religious conservatives have actually contributed to this insight. I would argue that a focus on actual biological sex rather than sexual or gender identity is really what's paramount in assessing anti-gay discrimination. So in Obergefell, the same-sex marriage case, states defending their laws that forbade same-sex marriage strenuously denied that their concern was homosexuality versus heterosexuality. Of course, homosexuals are fine people, they said. They're capable of healthy relationships and raising children. Rather, the state said, the reason marriage should be restricted to opposite-sex couples was because men and women were uniquely capable of conjugal marriage while same-sex couples were not. A brief filed by Mr. Bursch to the Supreme Court on behalf of Michigan said marriage as a public institution springs from a feature of opposite-sex relationships that is biologically different from all other relationships. The sexual union of a man or woman produces something that just an emotional relationship between two people cannot, the possibility of creating new life. Michigan did not argue that homosexuals should be denied marriage because of something inherent in homosexual orientation. Rather, they argue that a man who sleeps with a man is not capable of doing something that can happen when a man sleeps with a woman, the birth of a child. Just change the sex and you've got a different sort of thing. Well, Mr. Bursch was not wrong on that point. That is true. Now, the Supreme Court didn't buy the idea that that was a good enough reason to deny marriage equality, but the very purpose of Title VII is to deny the significance of such sex differences for purposes of employment. Again, nobody denies that they have an effect in terms of the ability to produce children, that it is the biological difference in sex that is relevant there. Title VII just says that's different, that's irrelevant for purposes of employment. The second major criticism, I think, against the decision is, well, who gets to say what textualism is? At the heart of this is a debate, I think, among conservatives about whether this is really a textualist decision or something else. Justice Alito said the court attempts to pass off its decision as the inevitable product of a textualist school of statutory interpretation championed by Justice Scalia, but no one should be fooled. The court's opinion is like a pirate ship. It sails under a textualist flag, but actually represents a theory of statutory interpretation that Justice Scalia excoriated, the theory that courts should update old statutes so they better reflect our current values of society. In other words, according to Justice Alito, we're supposed to believe that what's really happening here is that Neil Gorsuch and John Roberts were actually closet liberals using disingenuous legal methods to smuggle in their preferred policy values. Well, of course, I don't think anything believes that. That rings hollow. As Andrew Koppelman, a scholar at Northwestern, said, the Bostock case shows that Roberts and Gorsuch, neither of whom had ever before voted to support a gay rights claim, simply take their textualism seriously. And I think the sort of over-the-top tone of Justice Alito's dissent suggests that he is the one who is really animated by substantive policy views. He's aggrieved because what Justice Scalia told him textualism was about, or what he thought textualism was about, was something that was always supposed to produce conservative outcomes that Justice Alito prefers. His main objection is that Congress in 1964 couldn't have thought that outlawing sex discrimination meant outlawing discrimination against a gay or lesbian or transgender person. But again, from what we know of the history of how the court has interpreted Title VII over the years, that point really counts for nothing. New applications of the statutory language have happened frequently. According to Justice Scalia, appeals to things like common sense or what Congress intended are simply not the measure. As Justice Scalia said in Cale, if clear the male and male sexual harassment case, if clear statutory text produces a result that's at odds with the statute's apparent overall purpose, the text must nonetheless be followed. And in another case, when he was on the DC Circuit, Justice Scalia said judges interpret laws rather than reconstruct legislators' intentions. It is incompatible with a democratic government or a fair government to have the meaning of a law determined by what the lawgiver meant rather than what the lawgiver promulgated in terms of text. Finally, I've got 1 minute left. Let me anticipate that the third major criticism, I think, of the Bostock decision is based on its consequences. The women's shelter that now may be forced to hire a biologically male transgender woman, or things about sports teams if this gets extended to Title IX. And I think the answer there is not to ask the court to make legislative choices and judgments. The court's role here was articulating and clarifying what sex means. Now, if the consequences of that are problematic, the answer is to make the case to Congress. The Title VII or other federal sex discrimination laws may need some kind of adjustment. After all, this was not a constitutional ruling. This can be overridden in part or entirely by Congress. And finally, just a very brief word, what about the consequences for religious liberty? The court has reminded us, for one, there is a very generous ministerial exception that's been read into Title VII to protect truly religious organizations and functions from its application. But once again, as Justice Scalia reminded us some years ago, conscientious scruples have not relieved the individual from obedience to a general law that is not aimed at promoting or restricting religious beliefs. The mere possession of religious convictions that contradict the relevant concerns of a political society does not relieve the citizen from the discharge of political responsibilities. That is, obeying the law as Title VII exists and as the Supreme Court has given it to us. So I'm sorry I went about 48 seconds over the 10-minute limit. I hope that's interesting and gets us off to a good start, and I look forward to Mr. Bursch's presentation and then the dialogue.
Thank you, Professor Sanders. I think that's a great start, and I'm really delighted to be here, and thank both FedSoc chapters for hosting this debate. I think where Professor Sanders and I may start off on the wrong foot is what textualism is all about. The purpose of textualism is to determine a statutory text's original public meaning. That is, to discern how an ordinary American with a reasonable command of the English language would have understood the phrase "to discriminate against because of sex" when Title VII was enacted in 1964. And the problem with the Bostock opinion is that every American with a reasonable command of the English language in 1964 would have understood Title VII as prohibiting an employer from treating men better than women, or vice versa. No American would have understood the statute as covering the termination of an employee because they had a classification of being gay or transgender. In other words, requiring an employer to treat a man as a woman. And if no American would have understood the text that way, it's simply not possible to say that the court's interpretation reflects the original public meaning. In fact, it's the exact opposite. What the majority opinion did, as Justice Scalia described, or Alito described it, is a mere caricature of textualism, one that uses an interpretive methodology better described as literalism, where he simply ripped the text from the historical context and what any American at the time of enactment would have understood the law to mean. And that is distinctly not textualism. So I would like to start with how an actual textualist would analyze the statutory language and then respond to some of Professor Sanders' points. That the key phrase here is discriminate because of sex. The word discriminate is actually the key word here, not sex, as I'll discuss in a moment, because discriminate has two different meanings. One is to discriminate among different things. So for example, I can discriminate among the voices in a choir, but it can also mean less favorable treatment of people of certain classes. And certainly the latter definition is the one that someone in 1964 would have understood discriminate to mean, because no one would have thought that it was improper to consider differences in sex when assigning sex-specific specific bathrooms, restrooms, dress codes, overnight facilities, and the like. They would have acknowledged that differences in sex could be acknowledged. What they would have said was that discriminate means you can't treat women as a class or any woman as part of that class less favorably than a man or the class of men simply because she's a woman. Because of is relatively simple. It's a reason for something. And then sex, which is where many of the commentators focus, that the court actually agreed with the employers in this case, that sex, as someone with a reasonable command of English language in 1964 would have understood it, meant biological sex, something that could be determined based on your genes or your reproductive capacity. It was something that was fixed and objective, not something that was professed and subjective and subject to change. So if you put those three concepts together, discriminate because of and sex, what you have is that an employer cannot treat one sex more favorably than the other because of sex. And for decades, that's exactly the way the US Supreme Court defined that phrase in Manhart and Price Waterhouse and On-Call. In each one of those decisions reflecting the original public meaning of the statute. It'll be no surprise to any of you then that in the half a century plus since Title VII was enacted, that Congress viewed it that way too. In fact, Congress considered and rejected nearly 50 proposals to add the word sexual orientation to Title VII. Another dozen times rejected the phrase transgender status. And dozens of state legislatures and local governments have added anti-discrimination provisions based on those concepts, believing that they were protecting members of classes that Title VII did not cover. In fact, they've trumpeted it loudly that this is a great accomplishment, that now finally people in the LGBT community have these protections in employment law that they previously did not have anywhere. Likewise, Congress has used the concepts of sexual orientation and transgender status or identity in other statutes at the same time that they were using the word sex, demonstrating that they, again, even in modern times, saw that those were different concepts. So now apply that to the situation here. And let's start with the funeral home, which had the transgender employee. The proper comparator for the employee who wanted to dress and present as the opposite sex would be a member of the opposite sex who likewise wanted to violate the company's sex-specific dress code. So you have a man who wants to violate the sex-specific dress code, and you have a woman who wants to violate a sex-specific dress code. In both cases, the employer would say, no, you have to follow the dress code that we have according to your sex, not according to your gender identity. That is not discrimination because it does not treat one member of one sex worse than the other sex simply because of their sex. And the same would be true of the hypothetical that Professor Sanders used with the homosexual and a heterosexual employee. If you had one man who wanted to marry a same-sex partner and you had another man who wanted to marry an opposite-sex partner, those are not comparable individuals for purposes of a sex discrimination analysis. You're actually adding a second factor. You're adding their orientation, their sexual orientation. The only thing that you could do is look at someone who shared a sexual orientation and use them as a comparator, because if you don't do that, then you don't know whether the discrimination is occurring because of the sexual orientation or because of sex. They are two different concepts. So if an employer said that a man could not marry a man and a woman could not marry a woman, there is no sex discrimination because each of them is being treated the same vis-a-vis the opposite sex. In contrast, if you had a man who was not allowed to marry a same-sex partner, but a woman who was allowed to marry a same-sex partner, that would be sexual discrimination, as everyone has always understood Title VII, because the woman is being treated more advantageously than the man. Now, we know that applying a true sexualist or textualist reading, the mere noting of sex, as I mentioned, is insufficient for liability. And I want to give one example that really drives this point home. Imagine that you had a company that had a public beach or pool, and they were responsible for providing the safety at that facility or at that beach. And so they hired lifeguards, and they had a sex-specific dress code for those lifeguards. If you were a male lifeguard, you had to have at least swim trunks. But if you were a female lifeguard, you had to have both something covering the bottom and something covering the chest region. Now, no one in 1964 would have looked at a policy like that and said, as Justice Gorsuch does in the majority opinion, that that's sex discrimination because it treats one sex differently than the other. They would have said, no, it's merely noticing that the sexes are different and then treating them according to their sex, but not treating one disadvantageously against the other is not sex discrimination in the way that we understand it. All right, so just briefly with the time I have left to respond to a couple of Professor Sanders' points. He notes that since 1964, the courts have recognized a number of concepts that the Congress people who enacted Title VII might not have thought of, might not have had in their heads as being sex discrimination at the time that they put these words on the page. And that's not something that I necessarily disagree with. While every statute's meaning is fixed at the time of enactment, new applications may arise in light of changes. So for example, to take a really simple hypothetical, if an employer today gave smartphones to all the male employees, but refused to give any phones at all to female employees, that would be sex discrimination, even though no one in Congress in 1964 would have anticipated the idea of cell phones. But what he's talking about is something different altogether, because as I mentioned, the average American with a common understanding of English would have understood sex discrimination to mean treating women worse than men or vice versa. That naturally, that meaning would have included treating someone worse in a hostile environment type situation. If a male employer or supervisor did not fire the woman, but simply treated her to sexual harassment and advancements and things like that, and threatened to do terrible things to her employment if she didn't comply with those advances, that's clearly treating a woman different than a man would have in an identical situation. And in fact, all of the examples that he gives, gender stereotypes, that's the Price Waterhouse case, the male on male harassment, that's on call. In every single one of those cases, the US Supreme Court's opinion affirmed the sex discrimination test, treating men worse than women or vice versa because of sex. So consider on-cal. That was an instance where you had a male supervisor who was sexually harassing a male subordinate. And what the court said in that case was not that somehow harassment involving sexual orientation was sex discrimination. No, but rather that a female employee would not have been subjected to the same advances and harassment as the male employee because the supervisor was gay. So again, they reaffirmed the idea that you had to prove that a man was being treated worse than a woman in a comparable situation because of sex or vice versa. The same was the situation in Price Waterhouse. It involved a female at Price Waterhouse who was up for partnership. And she was denied that partnership for reasons that would have been encouraged in a man. Her review said that she was aggressive and not refined and not delicate enough, that she dressed in a masculine fashion. Those exact same characteristics would have been rewarded if they had been identified in a male employee, and yet a male employee would have been advanced to partnership and the female employee was not. Again, a woman was treated worse than a man because of sex, not because of any other consideration. And you can see how simply this works if you merely consider an employment application. Say that an employer has an application and it says, identify whether you're a male or a female, and then they hire all the females and they don't hire all the males. Everyone can immediately see that that's sex discrimination. But if the employment application doesn't ask for the employees or the applicant's sex and simply says, are you gay or are you straight? Are you cisgender or are you transgender? The employer has no idea whether they're male or female. If they were discriminating at all, it would be on these separate classifications. And that demonstrates that those classifications are not the same classifications as sex. The point about Justice Gorsuch and Chief Justice Roberts having never voted for a plaintiff in an LGBT case before, that's inaccurate. And not many people know this, so I don't fault Professor Sanders for this. But when Justice Gorsuch was then Judge Gorsuch on the 10th Circuit, he sat by designation on a 9th Circuit panel and in a per curiam opinion issued a ruling that looked very similar to this one. He said that under then existing 9th Circuit precedent that you could state a prima facie case under Title VII if you were a transgender employee, although he ultimately concurred with the rest of the panel that the employer prevailed in that case because they had legitimate non-discriminatory reasons for not retaining the employee. Namely, they wanted to ensure safety in the restrooms, and there was a dispute about that. And I see that my 10 minutes has passed, so I will save the consequences going to Congress, other than to note that the court should not be rewriting laws in accordance with policy preferences of anyone. They should simply apply the plain language. And although they did that in a literalist manner here, that is not a manner that the court should or will follow in the future, I predict. It should have been textualist. And if they had done that, then it would have been up to Congress to make that amendment. And that's something that to date they've declined to do.
Okay, so I'll thank you very much, John. So I'll take my 5 minutes to respond on a couple of points. One, well, first of all, thankfully, I think everything that Professor Birch, or I'm sorry, Mr. Birch has said is anticipated and addressed in the opinion. So you can read the majority opinion. I think every one of these points is something that Justice Gorsuch anticipates and at least attempts to refute. And, we're training you as law students. You can read it for yourself and decide whether you're persuaded by the hypothetical examples and the sort of linguistic analysis that the majority does. But I think everything that Mr. Birch has said is addressed in the opinion. Is this textualism or not? And does real textualism depend on original public meaning? My understanding is that that's originalism and not necessarily textualism. The court says the fact that a statute has been applied in situations not expressly anticipated by Congress, and I think anticipated by Congress is simply another way of saying what people at the time would have thought that the statute meant, does not demonstrate ambiguity. It simply demonstrates the breadth of legislative command. And once again, Justice Scalia would often remind us that the way a statute is applied, its anticipated application is a different thing than the meaning of the words that the statute enacts. So is this textualism? Is this originalism? Who gets to say what textualism really means or not? It's a bit of an academic debate, and I think it's a good topic for seminars and law school discussions, but I'm not sure that saying, well, this isn't really textualism is necessarily, tells us why this is a bad decision. Talking about some of the court's other cases where it has applied Title VII in other situations, Mr. Birch says that all of those situations demonstrate or all sort of ultimately come back to the original purpose of Title VII, which was to prevent the disparate treatment of men versus women. I'm really not sure how the Ancale case does that. I mean, women were not present in that case. You had male on male sexual harassment, and the court said, a man treating a man badly is also covered by Title VII, just like a man treating a woman badly is, or a woman treating a man badly. In the Price Waterhouse case, I really don't, that was a case about a woman who was said to, dress like a man and swear like a sailor and had all sorts of masculine mannerisms. And that case was really about the difference in treatment between that kind of woman, a woman who looked butch and swore like a sailor, versus the kind of woman that the company thought she should be, somebody who's feminine and wore makeup and coiffed her hair. I don't see how that was about treating men differently or more advantageously than women. It was about a certain stereotype of how women should behave, what women are capable of, how women should present themselves, what women's social role is. And although the Bostock opinion doesn't pay a lot of attention to that, I think that's ultimately at the core insight here, that this is about stereotypes and generalizations about the proper roles of men as men or women versus women. As to the dress code at Harris Funeral Homes, at Mr. Birch's client, I really don't think this is about willingness to comply with a dress code. If we say that, it is essentially to deny the possibility, to deny the fact that Amy Stevens could transition genders. It is to deny respect to the idea that she is now identified as a woman, presenting to the world as a woman, and is perfectly willing to comply with the dress code standards for women in her workplace. To insist, no, you have to comply with the dress code standard for a man because you are really a man, is not about the willingness to observe a dress code for one's gender. It is about simply denying the possibility of one's gender transition based on religious beliefs or about something else. And I think I will. I think I will leave it there. Once again, I realize the difficulty of saying, well, just tell it to Congress. that the response to that is that the court shouldn't rewrite legislation. I hope I've persuaded you, but more importantly, if you read the opinions, I hope you will be persuaded that that is not what's going on here. Again, it doesn't stand to reason that people like Justice Gorsuch or Chief Justice Roberts would be interested in smuggling some kind of pro-gay rights agenda in, and they've got to distort textualism in order to do it. I think this is what they believe textualism requires. This is what they believe is consistent with Title VII, with the court's consistent interpretation of Title VII. But once again, this isn't a constitutional decision. If it's problematic, if it causes consequences that we're uncomfortable with, Congress can always override a Supreme Court decision about statutory interpretation.
All right, well, briefly, just hitting on a couple of those points. I think the notion of examining what Congress or individual Congress people would have anticipated is not what most modern textualists would consider textualism anymore. That does sound more like originalism. But the modern movement appears to be what an ordinary American would have thought at the time of enactment. And it has to be that way because we don't know what's in the head of any individual congressperson. And you could certainly write a legislative record through committee reports and other legislative history that would suggest that there was something in someone's head or in many people's heads, or maybe even in the entire Congress's head, that doesn't appear in the text. And so it's not enough to look inside the head of the congressperson, although sometimes that might shed insight on things. But we have to look at what the people thought. And again, I don't think any person, even Professor Sanders, would say that someone in 1964 hearing about this Title VII that was just enacted and looking at its language would have anticipated that it would apply to a situation that looks anything like this. And you can imagine other examples where a purported textualist writes an opinion that looks like this one, that really takes more of a literalist bent and then messes up entirely what Congress intended, after or even what the people intended. After all, the whole exercise of textualism is to try to take the policy that everyone understood was being enacted and then proclaim that for modern ears so that we know what was being enacted. Imagine that there was a statute passed during World War II that prohibited the possession of blockbusters. At that time, a blockbuster was most commonly known as a large bomb. And so that would prohibit an American citizen from having an explosive device of some sort in their neighborhood or in their city. But a blockbuster already would have been recognized by that time to be a hit Hollywood movie. So now imagine we come up today and there's a local prosecutor who decides they're going to prosecute someone because they've got the latest, greatest movie downloaded on their DVR or on some other device or on a thumb drive. Well, literally, Justice Gorsuch would say, well, it prohibits the possession of blockbuster. And people in 1964 would have understood that a blockbuster could include a movie. And therefore, because Congress chose to use this incredibly broad language of broad blockbuster, instead of saying, bomb or explosive device or something else, we are compelled by the text to allow this prosecution to go forward and allow citizens everywhere to be jailed for possessing blockbusters. Even at the same time that everyone would recognize, whether you're looking at Congress members or whether you're looking at individual citizens, that none of them would have understood the law to have meant that at the time that it was enacted. So there has to be something about fixing that meaning historically, and simply to invoke a broad meaning of language and then apply it to new situations that are not just mere applications, but actually change the meaning of the words is not textualism in any sense that we've understood it. So I think where Professor Sanders kind of gives up the case, and really Justice Gorsuch's opinion too, is when he said that the core insight about the case is that this is about stereotypes, because there was a stereotyping claim in this case, and the majority didn't address it. Justice Alito highlights that in his dissent as evidence that even the majority did not find the stereotype point persuasive, that Congress enacted a statute that prohibits discrimination because of sex, not stereotypes because of sex. And yet it is only through the prism of stereotypes that you can get to the situation that he describes with employee Stevens and the dress code, that you're making a stereotype about how a man should dress, and that a man should not dress and present as a woman, that's a stereotype, and that Title VII prohibits that. Well, that's the entire point. Title VII doesn't prohibit that. And so if you're forced to look through a stereotype prism in order to get the result that you want, then you've done something that even Justice Gorsuch, in his opinion, wouldn't do with his literalist interpretation of the statute. And so when he says that this isn't about a dress code, it's about denying a respect to gender change. Well, again, that's the whole point. Sex-specific dress codes are something that the courts and the EEOC itself and its employer's compliance manual have acknowledged for years do not violate Title VII. And yet now, because a male employee wants to violate a sex-specific dress code and dress as a woman, somehow that becomes a violation of Title VII. Well, that doesn't make any sense. And it creates other problems, as Stevens described in deposition testimony. Prior to the case being decided on the merits, someone asked Stevens at a deposition, well, what if there was a biological male employee who was bald and had a beard, and they wanted to wear a dress and high heels to work? Is the employer forced to allow them to do that? And Stevens said, well, of course not, because the employee has to play the part. In other words, if the employee doesn't look enough like a woman, then the employee can't dress like a woman, no matter how they identify. So under the Stevens position, which the position the ACLU pushed in this case, an employer would not only have to engage in stereotypes, they would have to enforce the worst kinds of stereotypes. They would have to decide for themselves how they thought women or men should dress, and then conform dress codes that they followed that perception of how women and men should be. And I don't think anybody thinks that employers should be getting into that kind of analysis. And that's why this case is one that would have been appropriately resolved in Congress. In states and local governments which have added these classifications to employment discrimination provisions by legislation, they're able to make accommodations for the sex-specific shower, for the overnight accommodations, for the dress code, for the beach, when you're talking about the male and the female lifeguards, the things that take account of the differences in men's and women's bodies that represent biology, not bigotry. But by doing it through a judicial edict, you've now wiped the slate of the ability to draw those careful kinds of nuances in a carefully articulated statute. And that's done exactly the opposite of what the court is supposed to do, which is simply apply the policy that Congress adopted in 1964.
And I'd say not at all. There's not a reason in the world why people can't go to Congress tomorrow and tell them to do that, to create those exceptions, to tailor the legislation in that way. Again, this isn't a constitutional decision. It doesn't take the decision out of the hands of Congress.
So I think at this point, we're more than happy to take all the questions you can muster. Okay. Oh, Kylie, I believe you're muted.
Yeah, thank you both so much. That was really interesting, and I think we have some questions in our chat box ready for both of you. So this question is for Professor Sanders. Mm-hmm. Do you give any weight to the original community's expected applications in determining a text's meaning?
So when I was honored to be asked to do this, but I did give the caveat. I myself do not teach statutory interpretation. I don't profess to be an expert on it. So I do respect Justice Gorsuch's expertise in textualism, and I hear Justice Gorsuch quoting Justice Scalia saying that no, in statutory interpretation, the original intent. It was the question of original intended application. Was that the wording of the question? No, but my understanding is, according to Justice Gorsuch, leaning on Justice Scalia, the words, the meaning at the time of the words is dispositive, but how that might be applied, how those words might be applied in a given case, in a given set of facts down the road, is not what the textualist is supposed to be concerned about. It is very much what, in constitutional terms, the justice who believes in the original intended, the original public meaning, tied, and also believes that means original intended application. But there's a robust debate in originalism, in constitutional originalism, that says one can be faithful to the original intended meaning of a provision while not being bound by what the legislators or the people who passed that constitutional provision expected in terms of its application down the road. So my understanding of textualism is that we're not supposed to worry about how it might be applied down the road. But again, you can just change the definition of textualism and say, well, you're supposed to worry about that. But that's how we define textualism. And I'm not sure how you break out of that sort of then circular disagreement.
And I would agree with that, most textualists would say that anticipated applications are not something that's required because things do change. And I gave the hypothetical of the employer who gave all the smartphones to the male employees, but refused to give them to the female employees. Was that an expected application by anyone in 1964? Well, no, because they did not anticipate smartphones. But is that an expected application based on the principle that men cannot be treated better than women because they are men? Absolutely, and I think that fits perfectly. Interestingly, the Supreme Court was confronted with the very question in an earlier Title VII case, 1976. It's the General Electric versus Gilbert case. And the question there was whether it was sex discrimination to treat women differently because of pregnancy. And the Supreme Court in that case, I think appropriately said, Title VII doesn't cover pregnancy, because the physical differences between men and women are not treating men and women differently because of their sex in an unfair way. And it was an act of Congress then that had to amend the statute and add pregnancy as a protected classification. And that's the same way that Title VII should have played out in the context of these cases.
I think my understanding of that history is one reason Congress did that is there was such outrage and such criticism of the court's, what was seen as the court's poor reasoning that, well, that's discrimination on the basis of a medical condition, not on the basis of disadvantage to a sex. I mean, we can, you're right, Congress did change it in response to something the court did, but I think my understanding is the court's reasoning in that decision has been sort of mercilessly criticized by a broad swath of commentators.
Also could have been that people were just upset with the result, and when you don't like the result under the plain text, then you amend the statute.
We have another question. This one is for both speakers, but directed primarily towards Professor Sanders. And the question is there something to be said for the fact that, as Mr. Bursch put it, you can discriminate against applicants for a job based on no knowledge of their sex, but only knowledge of their sexual orientation as homosexual or heterosexual? Does that not go directly against the idea that by discriminating against sexual orientation, you are necessarily discriminating against sex?
Yeah, once again, Justice Gorsuch in the opinion responds directly to that criticism, directly to that point, which was a powerful point that Justice Alito made. And I can't find it now immediately in the opinion, but I think the response is essentially, when the employer does that, the employer is still making a judgment about, you're telling me that person's gay. Well, I know that means either that they're a man who wants to sleep with a man, and I think that's wrong, or they're a woman who wants to date a woman, and I think that's wrong. So yes, I would discriminate against him. I believe the answer that Justice Gorsuch gives is like, just because you are told they are homosexual, but you don't know whether they're a man or a woman, doesn't change the fact that the individual who is affected by that policy is either going to be a man who is romantically oriented toward men, and the employer doesn't like that idea, but a man who is romantically oriented toward women, the employer is fine with. So as I said, I can't find the passage in the opinion right now that sort of specifically addresses that, but I think it's basically that doesn't get around the core objection the employer has to that kind of employee. It is their behavior, their affection vis-a-vis other members of the same sex, and that's being treated one way, and it's not being treated when it's toward a member of the opposite sex.
Yeah, and I am familiar with that passage, and actually Professor Sanders defends the position even better than Justice Gorsuch's majority opinion does. In the opinion, he basically says, well, it's impossible to be able to define someone's sexual orientation or their gender identity without reference to sex. And so, simply by having a sexless question in the application, you can't even define it without sex. So it's still related to sex, and therefore it must fall within the scope of this broad language. Well, that doesn't make any sense at all. Simply because you notice sex or because it's related to sex doesn't mean that it's sex discrimination. Again, the sex-specific restrooms. No one in 1964 would have thought that was sex discrimination, even though you have to notice someone's sex to say you go in the men's bathroom and you go in the women's bathroom. And I think Professor Sanders' even better defense really elucidates the problem. He said, well, if you're talking about someone who's gay, they're either a gay man who likes other men or a gay woman who likes other women. But in either case, the employer still doesn't know whether it's a man or a woman. If all the employer is doing is giving differential treatment to one man who loves a man and another man who loves a woman, he is not treating men as either individually or as a class worse than a similarly situated woman. All he's doing is treating someone with sexual orientation that is same-sex attracted different than someone who is opposite sex attracted. And those are distinct categories. And the Supreme Court had a previous case that applied that analysis too. It was the Espinoza case. If you're in law school right now, you're familiar with the recent Espinoza decision involving the Montana Blaine Amendment. But this Espinoza was a Title VII case. And the question was whether national origin discrimination, which Title VII also prohibits, includes discrimination based on alienage status. And in the same way that to know whether someone is a heterosexual or a homosexual orientation, you have to know their sex. To know someone's alienage status, you have to know their national origin, and you also need to know where they're living now. And yet the court said those are two distinct categories. And if Congress wants to add an alienage status to Title VII, that's their prerogative to do that. But simply because you have to notice their national origin in order to be able to determine their alienage status, that doesn't mean that alienage classifications are covered under Title VII. And it works the same way here.
I want to sort of cop to something Mr. Bursch said earlier, and that is, I do think that the gender stereotyping idea here does work, even though that it's helpful in the analysis, even though Justice Gorsuch, for whatever reason, eschews that. The court has not overruled Price Waterhouse, and Price Waterhouse was clearly based on the idea of gender stereotypes. So I don't think you can say that idea has disappeared from Title VII law. I also think it's interesting that we get hung up on this label. Well, are you a homosexual or a heterosexual, and is that why you're being fired? What if you have a woman who says, "Look, I don't buy into those labels. I'm not interested in having my identity policed, but let me introduce you to my female friend or my female lover or my female spouse. Don't pigeonhole me as lesbian. Maybe I'm bisexual. Maybe I don't want to think about it. All I know is I date and sleep with members of the same sex." Presumably the employer is going to be the employer is not going to be hung up on how she labels herself. The employer is going to be hung up on her behavior, on what she actually does, how she enacts her feelings, and that's what they're going to punish the employee on the basis of. So I think that illustrates, it's sort of pointless to get hung up on hanging a label on something, because then we're getting into essentially whether it's the identity that's being punished rather than
Yeah, I embrace that analysis, because it's not the identity of the individual as man or woman that's dispositive. It's their behavior, it's their attraction. And those are things that Title VII doesn't cover, because sex is biological sex. It doesn't cover behavior, it doesn't cover attraction. And that's why Justice Gorsuch got it wrong. One real quick rebuttal, and I know there's more questions, on Price Waterhouse. Price Waterhouse did not establish sex stereotyping as a new cause of action under Title VII. What the court said specifically was that sex stereotyping could be used as evidence to prove sex discrimination, which the court then reiterated was treating women differently than men because they are women, or vice versa.
Okay, we have another question. So this is directed to both speakers. As experienced advocates yourselves, would you give students advice about how to use textualism as a litigation strategy in statutory interpretation cases? Where does it fit into an argument in a case like this?
Do you want me to take that first, Professor?
Sure, because I'm not really sure I have all that much to say. Well, yeah, no, please, go ahead.
Yeah. Well, very famously in an oral argument just a couple of years ago, there was a lawyer in the Supreme Court who was trying to make a strong policy argument based on a statute. And Justice Kagan stopped them and said, that's the kind of policy argument that people used to make here all the time, but we're all textualists now. Now, I'm not sure whether that's entirely accurate when she says that we're all textualists now, but certainly if one thing I think everybody can agree on is that Justice Scalia's textualist movement has really taken the courts by storm, and that it would be rare to find a judge who would say, I'm not going to worry about the exact terms that the legislature or Congress used. I'm just going to impose the policy preferences that I think the legislature, Congress would have best put into practice in this situation. So textualism really has to be the very first tool in the toolbox. It should be the opening argument that you make in any brief interpreting a statute or even a contract, and it should be the bulk of your argument. Now that said, textualism, by focusing on words and dictionaries alone, is never sufficient to get everybody's vote. So in addition to that, you've got to look at context, you've got to look at history, you've got to look at individual intent if you can find it in that history. You've got to look at policy ramifications. Not all textualist courts do this, but the US Supreme Court still has the absurd results doctrine that if we interpret the plain language of a statute and it causes an absurd result, then we assume that Congress didn't intend that. Well, why not? Maybe they intended to act absurdly in this situation. But you've got to run through that whole gamut of things right down to the last policy argument, because you don't know what a judge or a justice might accept at the end of the day. And the most persuasive advocate is the one who can take all of those tools and meld them in a way to show that their side is the one that makes the most sense, given everything that we know about the language and its context. So start with textualism, but never stop there, would be my advice.
And I guess I would disagree with that only because to me that sounds more like what a judge should do or what those who are making the law should do. My perspective, maybe it's just cynical, is, I don't think it's cynical, I think it's realistic, is that as an advocate, which is what the question was about, your job is to advance your client's position and to make all reasonable legal arguments that you can to win the case. And if textualism might be one thing in your toolbox, but it could be that a really sound textualist analysis is harmful to your client. And if that's the case, I would say don't do textualism. So I'm not sure it can be easily answered. I do think, again, it is for an advocate, it's a tool to be used. For a judge, for an academic, for someone who is sort of invested ideologically in a particular method of interpretation, then it is the sort of alpha and omega, I guess.
Okay, and I think we have time for one more question. So this one is about Hively, the Ivy Tech Community College from the 7th Circuit in 2017, where Judge Posner concurred with the pro-LGBTQ majority opinion. Judge Posner said that he was reluctant to join the majority because he thought their opinion distorted the ordinary meaning of sex. He wrote, "It's true that even today, if asked what is the sex of plaintiff Hively, one would answer that she is female or that she is a woman, not that she is a lesbian. Lesbianism denotes a form of sexual or romantic attraction. It is not a physical sex identifier." Nonetheless, he held for the lesbian plaintiff based on his own theory of judicial interpretive updating. What do you make of Judge Posner's argument and his theory of judicial interpretive updating and statutory interpretation? And I think this is directed at both speakers.
Okay.
Go ahead.
John, do you want to go first? Do you want me to?
Go ahead, yeah.
I'm not sure. So again, I am not like deeply invested in defending Gorsuch's opinion, within its four corners. I feel more deeply invested in defending the ultimate result that this case has come to, that so did Hively, and there were some differences in the analysis in those cases. I mean, my view of Judge Posner's concurrence in the Hively decision has always been that I think maybe this is agreeing with the criticism, and maybe it's something that John will ding me for. I mean, I think Judge Posner was being honest about what the majority in that opinion was actually doing. I think there is some sense in which, in that particular opinion, which was not a textualist pure exercise the way the Bostock purports to be, in that opinion, I think Judge Posner's opinion concurrence did carry some weight, because I think that the idea that, our modern sensibilities about what sex means, the insights that we have about what role sex plays in our lives, and the intersection between sex and sexual orientation or gender identity is important. Not so much that it's judicial updating, like, well, we think it's time to change the statute. It is more a matter of bringing contemporary knowledge, learning, understanding to the enterprise of statutory interpretation. So if we agree that that's what Judge Posner was talking about, then I think there is merit in what he's saying. And I think it nicely augmented, fleshed out, complemented, shed light on what the majority in the Hively case was doing. But of course, in this case, the gay and lesbian plaintiffs wanted to run from Judge Posner's opinion because they were denying that that's what they were doing. They said this is purely about this sort of mathematical, sex discrimination sort of way of viewing things. So anyway.
Well, I agree 100% with Professor Sanders that Judge Posner was being honest when he wrote that. I think he was laying all his cards out there. But I disagree that what he was doing was taking contemporary knowledge and using it to somehow shed light on what it means to engage in sex discrimination. Because Judge Posner had it exactly right, that when you're talking about sexual orientation, you're talking about something completely different than what it means to be a man or a woman. What he meant by judicial updating was that we could look at the primary evil that Congress was trying to address in Title VII. And as Professor Sanders stated it eloquently at the beginning, it was to get rid of irrational discrimination based on irrelevant classifications. Then it only makes sense that we would update it to include sexual orientation and gender identity, because discrimination on those bases too is improper, would be in his view. But if that's your view, then you could also update Title VII to eliminate discrimination based on height and weight and your favorite football team, and all kinds of other things that are also irrelevant to job performance. And yet no one would suggest that those things should be added to the statute by judges, no less, much less Congress. And the reason for that is because it deviates so substantially from what Congress actually did when it put those words on a piece of paper. So Judge Posner was right when he said that it was incompatible with the understanding of the terminology sex and sexual orientation to lump those into the same category and say that one covered the other. But he was wrong to say that it was the judge's job to then create a new classification that the statute did not include. There are all kinds of rational reasons why employers may not treat employees differently based on sexual orientation that have entirely to do with positive motives, religious beliefs about what's best for human flourishing and about what protects the dignity of the human person. And we can have those types of policy disagreements, but those are the ones that are most well suited for the floor of Congress and not for a judicial opinion.
I once attended a conference where Justice Posner, in an unguarded moment, said, "Oh, Congress is an international embarrassment." So I think we can both agree that Judge Posner felt free to sort of, say that he thought he was smarter than Congress anyway.
Yeah, I think that's true.
Okay, well, I think that that's the last word, and thank you both so much for participating. This was a really wonderful debate. I think everybody really enjoyed it. And thank you so much to IU Student Chapter for co-hosting with us. We really appreciate it. And also we'd like to remind you that our next event is going to be this Thursday. It's going to be a debate about police reform between Mark Levin and Josh Hammer, moderated by our very own Professor Lee Kowarski here at UT and co-hosted with the Texas Public Policy Foundation. And Mike has dropped that registration link in the chat for you all. So please attend. It'll be a wonderful event. And thank you so much for your participation tonight.
Yeah, if I could thank Professor Sanders one more time, it was an absolute delight tonight. So thank you for your participation.
Same here. It would be fun to face you as a courtroom as advocates. So or even maybe to be on the same side. I think there are some issues where we actually would agree. So
I'm sure. Yeah.
Thank you both very much.
Okay. And thanks to the student chapter sponsors as well. Great event. Nice turnout.
An excellent job moderating. Thank you.